Good morning. I'm Judge Leslie Kim Smith. We are now live streaming on YouTube and on the record. Calling case number 21008437CD in the matter of Leuven versus Pro Carpentry LLC. Counsel, will you place your appearances on the record starting plaintiff's counsel?
Yes, Your Honor. Attorney Jim Razen and Attorney Amanda Washburn on behalf of the plaintiffs. Good morning.
Good morning.
Andrew
Oh,
Oh,
Bean
Mr.
on
Bean.
behalf of the defendant. Good morning, Your Honor.
I'm sorry, Mr. Bean, if you could repeat that, you froze up for a moment.
Yes, Andrew Bean on behalf of the plaintiff, Your Honor. Excuse me, defendant, Your Honor.
All right. And you have your client here. Ma'am, I'm sorry, I don't know your name. If you could state your name for the record.
Adriana McGee.
McGee. Right. All right. May the record reflect this is the date and time scheduled for defendant's motion for summary disposition. I did get a chance to speak to counsel off record possible settlements of this matter. However, the parties wish the court to proceed on defendant's motion for summary disposition. I've had an opportunity to view the pleadings, and Mr. Bean, if you're ready to proceed, you may begin.
Thank you, Your Honor. And I appreciate that you've already read the pleading, so I'll briefly go over some of the allegations briefly. So there are 5 instances, as I understand it, that are involved in this case with respect to the alleged discrimination and or racial harassment claim. One claim is that some other contractors were having a conversation about the then election of potential President Harris. And there were some comments made of a potentially racially derogatory nature, and that the plaintiff claims that he complained about those instances. My client indicates that there were no complaints about those instances at all. And again, it's important for the court to understand and realize that these were comments made by some other contractors on the job. And those contractors' names and identities are unknown to us. The second incident supposedly took place when a carve out or some wooden plaque that looked like a black penis was stuck on top of a garage at a work site. It's important for the court to know that my client was not working on that particular building. It's important for the court to know that this work site was attended by numerous other contractors and subcontractors who are doing work. It's important for the court to note that also the witnesses, other than the plaintiff, have indicated they did not see this penis that was placed. In any event, what the plaintiff admits is, well, I saw it and I asked my employer, if you want to call him an employer, or the contractor I was working for, Pro Carpentry, please take that black penis down. And that black penis came down within a day or two at the very latest as to when the penis was supposedly observed. That's from page 37 of the plaintiff's deposition, where he says, what happened after you complained? They took it down. And who took it down? My supervisor, Nick. He also acknowledges with respect to the penis that he doesn't know who put it up there or who created it. That's at page 39 and 40 of his deposition. Did you ask anybody who created it? And he said, nobody told me and I didn't ask. So there's really no connection there whatsoever that can be made with respect to Pro Carpentry's wrongdoing or alleged wrongdoing as to that incident. The next incident, he indicates that he was walking up behind a group of some other contractors, again, unidentified persons, who said words to the effect, oh, we finally got color working for us. Again, my client testified that this incident was not even raised to him, was not brought to their attention, didn't know anything about it. And again, it's some unknown other contractors working at the site. The fourth incident he alleges is that there was a flag that was put on the site. And he claims that it was Trump for president, fuck your feelings, is supposedly what was said on the flag. Nobody has the flag. He doesn't have a copy of the flag or a picture of the flag. My client says there was no such flag that was flown. My client explains, uncontroverted, that they did put up a flag on a crane, and they do that for OSHA purposes to figure out where the wind is going. The person who put the flag up has testified he had no political motivation or racial motivation in doing so. I don't exactly see how Trump for president, even if it said fuck your feelings, pardon my French, translates to a racial incident or event in any event. So I don't see how that connects. But again, the plaintiff testified when I was upset about the flag, I complained about it. They took it down immediately. Prompt remedial action taken with respect to this flag, just like there was with respect to the penis, just like there was with respect to any other complaint that was made and actually brought to my client's attention. The plaintiff, again, admits at page 47 that I asked them to take the flag down, and they took it down that day or maybe a day later. Plaintiff also indicates and testified at page 63 of his deposition that, anytime he did make a complaint, Nick, his supervisor, did something. Okay. He may not have been overly happy with what Nick did, but he responded each and every time that he made a complaint. And he also acknowledges, the plaintiff does, that after this next incident, which I'm going to talk about for a moment, the company brought out training for all the contractors on the job and said, we can't engage in any sort of racial wrongdoing or in any of these jokings. All needs to stop. And the plaintiff acknowledges that action was also taken. Now, with respect to the next incident that he relies upon, he claims that another contractor, a Caleb Farrar, was playing racially insensitive music, and that he complained about it. My client did an investigation of that quickly, immediately, and was ready to terminate Mr. Farrar as a result of this music that was being played that was racially insensitive. And my client said to the plaintiff, I'm ready to terminate Mr. Farrar. And the plaintiff has testified, it was just a misunderstanding. We're cool. Don't do anything. Well, again, my client was ready to take proper remedial action. The plaintiff said it was just a misunderstanding. In any event, notwithstanding that, my client did separate Mr. Farrar and the plaintiff, so they wouldn't work together any further, would not have any contact with each other. Those instances, those 5 instances I've talked about, if you analyze them under Krohn, K-R-O-H-N versus Sedgwick, 244 Mishap, 289, these instances, simply taken separately or even in totality, don't raise to the level of being actionable. In Krohn, the court said, you must consider whether these comments were made by a decision maker or just by an agent. Here we know that all these actions were not made by a decision maker, and I'll explain that in a moment, but David McGee, the owner of the company, was the decision maker as to the ultimate termination of the plaintiff. The other 3 considerations under Krohn that you have to take into account are whether these were in any way related to the decision-making process. And I'll explain in a moment. None of them were. Also, were these comments vague, ambiguous, or isolated? Our contention, 5 instances at worst over the course of his time with the company were at most isolated or ambiguous. Am I still there, Your Honor? I do see that my internet connection is unstable.
No, I'll let you know if you freeze up.
Okay, thank you. And then finally, the last Krohn factor is whether these instances were proximate in time to the termination. These instances all happened well before the termination came. And as a result, none of the Krohn factors exist here to turn these 5 alleged instances into a racially discriminatory or hostile environment. And the Krohn court also noted that comments made by a non-decision maker before adverse employment action is taken are not probative of the employer's discriminatory motivation. And I would submit that the fact that my client did act promptly, remedially on all of the complaints when they had them shows there was no discriminatory animus going on or motivation. Also, with respect to a hostile work environment, of course, we know that that must be severe and pervasive conduct to create an intimidating or abusive atmosphere. And not to pick on or to applaud Mr. Razor, but even on his website, Mr. Razor quotes that as the law. You have to have a severe and pervasive environment in order to establish a racially hostile work environment. These 5 isolated, vague, ambiguous comments, actions, even if they occurred by non-decision makers well before the termination, don't rise to the level of hostile environment. Now, with respect to the termination, yes, Mr. Levine was terminated or let go. He was a contractor, he wasn't an employee, but he was let go. And the reason for that is there was a situation where it was alleged that he supplied some drugs, and the person who took the drugs overdosed on the drugs, was very sick, very ill, and the police came, and the plaintiff is saying because the white people who were involved in that incident also were not disciplined or terminated, therefore there must be disparate treatment. But the white employees are different than Mr. Levine in these regards. First, as was explained in the motion, the plaintiff worked sporadically, very few hours. He would basically come and go when he wanted, didn't give our client much notice about when and where he would be there. That behavior was not engaged in by these white employees who were involved in the same incident. In fact, when the plaintiff was originally hired to work on a crew, he was very quickly terminated from that crew because he was not doing a good job. Again, that behavior was not engaged in by the white employees who they cite as comparables. In addition, my client received numerous complaints of other workers that the plaintiff was advertising drugs to them, trying to sell drugs. That is not the same behavior that the white employees engaged in. Multiple other contractors identified the plaintiff as the person who actually gave the person who overdosed on the drugs. No other white employee was disseminating or giving out the drugs, and so those white folks are not comparable. Also, my client received complaints of the plaintiff's aggressive tendencies and actions while at work. Again, my client did not receive those types of complaints with respect to the white comparable employees. Also, my client, David McGee, who was on site at the time of this alleged overdose, told the plaintiff, I need you to cooperate with me so I can do an employer investigation as to what really happened in this instance. And told him, if you leave, I will terminate you. And my client was under a contract with the general contractor that he had to do an investigation to figure out what was going on here. The plaintiff said, I'm leaving, and left. He wouldn't cooperate with the employer. He wouldn't cooperate with David to figure out what was going on with respect to this alleged overdose. The white employees cooperated, stuck around, told my client what was going on. The difference here is Mr. Levine left. He abandoned. He wouldn't cooperate. My client warned him not to stay. I need your cooperation. He left. Mr. McGee was the decision maker here to terminate him. Mr. McGee was not involved in any of the other 5 instances. Mr. McGee was the one who hired the plaintiff. If Mr. McGee was the one who had some sort of discriminatory animus against him, he wouldn't have hired him in the first place, and I believe that the same actor inference under Michigan law applies as well. Buttress the fact that there's nothing racial going on. There was no retaliation. And by the way, let me just speak with retaliation. Again, every time Mr. Levine actually complained, my client took remedial action. If they're really upset and wanted to get rid of him, they would have fired him with respect to any of these other 4 or 5 instances. For all these reasons, Your Honor, we believe that the motion should be granted, even if you assume all the things that the plaintiff claims occurred. They just don't rise to the level sufficient to meet the legal test. Thank you.
All right, thank you. And in response?
Thank you, Judge. Judge, on an MCR 2.116 C10 motion, obviously the court has to look at the facts in the matter in a light most favorable to the non-moving party, which is the plaintiff in this action. And this is a classic case, Judge, of dispute in facts that has to go to a jury for resolution. Let me tell you, Judge, the recitation of facts that you just heard were the facts in a light most favorable to the defendant. So I guess what I'll do first is put on the record the facts most favorable based on the testimony in a light most favorable to the plaintiff. So the first incident was that two of plaintiff's coworkers were discussing the 2020 presidential election, and they said, yeah, you're trying to set it up so that Kamala Harris for a N-word to win. Obviously, they didn't say N-word. They said the whole word. The courts have held that just the use of this particular word in a work environment states a case of discrimination pursuant to ELCRA. It's a word we can't even write. It's a word that you can't even say. And for the only African-American worker in the workplace with this first incident to hear that word in the workplace is unacceptable. And Levine immediately reported this to the foreman on the job site, Nick Young. Nick Young, in a classic, Judge, in a classic dispute of facts, says he never reported it to me. But plaintiff says he immediately reported it to him. And according to plaintiff, Foreman Young said, these guys just joke around. Try not to take it offensive or try not to take it personally. So instead of taking any action, plaintiff was essentially told to deal with the ongoing racism. The second issue or the second incident, and keep in mind, he did not work here a long time. Plaintiff is trying to say that these incidents were, isolated in some way. These were consistent incidents which happened every several days or weeks on the work site in a very short employment relationship. So these are not incidents that somehow are isolated to meet the standards that the Crone or Crown case, which I should add, defendant didn't cite the Crone or the Crown case. So if the court's going to use that as a basis, then we need an opportunity to refute the argument based on that with some supplemental briefing and argument. However, I know that case, and that case doesn't apply because that case talks about very isolated incidents that are attenuated, separated by years at a time, and whether that rises to severe or pervasive. This is not that case, because the second incident is that there was a Trump 2020 flag which said, fuck your feelings, hanging over the job site. But what the defendant fails to tell you, Judge, is that Levine's testimony was that the flag itself was superimposed on a Confederate flag. That's the part he doesn't tell you. Now, I'm not African American, but I can tell you that I am Jewish. And if somebody had a flag flying over a work site that had a Nazi flag on it, I would feel some kind of way about it. And I would not blame any African American for feeling a certain way about a Confederate flag flying over a workplace. And for the defendant to allege somehow that that is not offensive on a racial basis to the only African American employee on a work site, it just is beyond the pale. And certainly, Judge, a jury in Wayne County could certainly find that a Confederate flag flying anywhere is racial discrimination in the workplace. And their excuse for that is, well, we have to put a flag up on a crane. OSHA says we have to do it to test the wind direction. You do not have to put a Confederate flag with a political message up on a job site. OSHA doesn't say that. It's ridiculous. Then there's another incident which happens days later where a worker puts together a gigantic black colored representation of a penis and nails it to a building. Judge, I don't know if you can tell from the photograph because it got a little shrunk because of page limitations in the brief. This is a 4-foot high description of a penis that's colored black, that's purposefully colored black, nailed to a building with nails. When Levine sees it, he testifies that everybody else is laughing at it and laughing at him. Now, how in the world that's not discrimination based on race? And Judge, the defendant confuses some items that I guess is a good time to bring up that was clearly addressed by the Court of Appeals. They try to say, well, we don't know who did it. It could have been somebody else. It could have been a passerby. They even try to say, Judge, they even try to argue that construction workers naturally, if you give them any time, tools, and a piece of wood, will make a big black penis and nail it to a building. They even say that in their brief. Incredibly, one of their people testified to that, and I can't wait for them to tell a jury in Wayne County that construction workers will always migrate towards making gigantic black penises and nailing them to buildings. But the Court of Appeals said that the obligation of an employer is to create a workplace which is free of discrimination pursuant to ELCRA. So it doesn't really matter if it could have been kids across the street that made it. It wasn't, but it could have been, because the responsibility is on the employer to have a workplace free from racial discrimination. So their thought that, well, we don't know exactly who did it, doesn't mean that they shouldn't have taken it down or covered it immediately, especially with the plaintiff that's endured the N-word and a Confederate flag. But wait, there's more. And also, I guess it goes by saying that the owner of the company testified that he thought it was a replica of a Kid Rock album giving somebody the middle finger, which is ridiculous because everybody else in the world, including representatives of defendants' companies, said, yeah, it's a big black penis nailed to a wall. Then plaintiff was working behind some co-workers when they saw him and they said, oh, we finally got color. Oh, and let me go back to the big black penis. Of course, he complained about that. And there's a dispute, in fact, as to whether he complained, or they say that he didn't complain. He says that he does complain. Then plaintiff's walking behind a few coworkers when they see him and they say, oh, we finally got color working for us. Obviously, that's racial discrimination. And plaintiff said that he reported it to the foreman again, saying, hey, I don't know what's going on, but it feels like there's a lot of racist people out here, and I don't, know how to take it, He let him know that the pervasive racism was getting to him, and the foreman told him again, these guys joke around. They're jokesters. They joke. So, Judge, this is a atmosphere which is pervasively, and counsel's right, it does have a definition of severe and pervasive racism on the website. It's the definition from state law. It's got to be based on race. And obviously, all of this is based on race because there's another incident with Khalib. And remember, this is the guy who says that the drugs were given to him not sold to him, but given to him by my client. Khalib there's some rap music playing, and it includes the N-word in the rap music. Plaintiff asked Khalib to stop using the N-word because it was bothering him. When Khalib looked at Levine and said, I can say the N-word, the two almost had an altercation, but another coworker said Khalib's just ignorant, and they're trying to say that shows that our client's aggressive at work. No, I mean, if somebody looks at you and you're an African American person on a job site, and they look at you and they say, I can say N-word, Judge, a little aggressive behavior. I mean, he didn't hit him or anything, but telling somebody that that's inappropriate is completely appropriate in the workplace. Then the defendant says, well, Levine didn't want Khalib fired. It's not up to Levine to decide whether this person gets terminated based on this racism. It's up to the employer. The employer has the duty to have a workplace free from racial discrimination pursuant to Michigan law. They don't get a pass on this incident by saying, well, Levine said they didn't want to fire him, and they didn't produce any documentation at all. It's just the say-so of this owner who says we were going to fire him. They didn't produce any counseling or anything else indicating that they were going to fire this guy. And as a matter of fact, I believe, have a motion pending concerning the issues that we have with production of documents, because part of the documents that they didn't produce, Judge, was anything showing that Khalib was going to be fired for this. It's just what they're saying. Finally, Judge, we get to this incident where Joshua overdosed on on drugs at work requiring emergency attention. Khalib, who had been involved in the altercation with Levine, and Joshua, the man that overdosed, falsely accused plaintiff of providing them with drugs. There was never any corroboration of this. There's no other employees that say that Levine was dealing drugs. There's no police report. There's the Oakland County Sheriff's deputies who were called on the scene, did not investigate Levine. It's just the say-so of the person who was involved in the drug transaction, Khalib, who had previously been involved in an altercation over racially charged words that Khalib used and almost got fired, who said that Levine was involved in supplying drugs. That's it. The people with the motivation, the guy who overdosed and jeopardized the contract of the employer for the job site, and the guy who almost got fired because he called Levine the N-word, said that Levine supplied the drugs, blaming the only Black employer. And that's when the owner of the company, David McGee, terminated plaintiffs saying, quote, "Every time I get a call, it's something about you. Get your shit, you're fired," end quote. That's our client's testimony. Now, David McGee, in his deposition, says something differently. He says, "Oh, I'm trying, you can't leave," and Levine leaves. That is a classic question of fact, Judge, that a jury needs to figure out. Because if David McGee says to plaintiff, "Every time I get a call, it's something about you," and we know that David McGee got a lot of calls because every time plaintiff Levine complained about this severe and pervasive racism on the job site, David McGee got a call. So we know if the jury decides that David McGee said, "Every time I get a call, it's something about you, get your shit, you're fired," then that is retaliation based upon race. If the jury believes that the defendant's testimony that he was going to leave, then, and he said, and McGee said, "You've got to stay here for an investigation," and Levine said, "You're leaving," well, they'll find against us. But this all goes to questions of fact, Judge, that cannot be resolved in the summary disposition. Just to emphasize, the two white workers who took drugs and caused an overdose didn't get fired, but the African-American worker who they just alleged had given them drugs for free was let go. I mean, just think about that for a second. It's like it's like the essence of a factual dispute. And Judge, I don't mean to belabor it, but part of the reasons that you just heard from the defendant's attorney was that the typical things that defendants do in employment cases is to try to demean the worker. And so they say, "Oh, his work was sporadic. He only showed up when he wanted to." Well, no, because Foreman Young, whose deposition I took, when confronted with the worksheets, the timesheets of Levine, it showed that he actually worked more hours than the two other non-African American employees. And when I confronted McGee with those same timesheets, he had to admit the same. Yes, he worked more hours. The reason he was switched from one crew to the other, Judge, was to get him away from people who were racially harassing him, which may go to some sort of, militating factor or for the employer, but it's not his responsibility that they moved him in crews. They never wrote him up to fire him. They never said he was inconsistent with time. They never said his work was shoddy. He hadn't been given a PIP, a performance improvement plan, about anything like that. It's absolute smoke and mirrors, Judge, for them to try to allege that somehow there was anything wrong with the quality of his work. And they make this argument that they didn't know about the racism on the site, but McGee also testified, due to the racism on the site, I had a training session pertaining to discrimination. So it's one way or the other. They obviously knew about the racism on the site, but they didn't fire anybody. They did do a training session. According to my client, according to the handout, it was poorly done. It was a joke. People were laughing at it at the time. It was a pro forma performance to try to get out of liability that they later could not get out of, because McGee said to the guy, "Every time I come down here, it's all about you. Get your shit, you're fired." So what do I want you to do, Judge? Well, first of all, this is odd. So there is a employment discrimination case that we've been talking about pursuant to ELCRA. There is a hostile work environment pursuant to ELCRA, and the defendant briefed those. However, there's a count for discrimination place of public accommodation pursuant to ELCRA and a retaliation claim pursuant to ELCRA that the defendant ignored. They didn't move for summary disposition on those two counts. So, Judge, I don't see how the court can grant summary disposition on counts 3 and 4 because they didn't even brief them. They didn't even ask for those counts to be dismissed. So discrimination in public place of accommodation, and the case on that is Haynes. That's cited in our brief. Discrimination is a protected characteristic by a person resulting in a denial of full and equal enjoyment of facilities of a place of public accommodation. The Court of Appeals actually reinstated that claim. So we know that that claim lies, and they didn't brief it. So that claim has to go to a jury. Retaliation pursuant to ELCRA, that the plaintiff engaged in protected activity, which was reporting racism in the worksite. The defendant knew, and obviously the defendant knew, that there was an adverse action, which he was terminated, and there was a causal connection between the reporting things and the firing, which was every time I'm down here at this job site, it's all about you, get your shit, you're gone. That's the causal connection. And legitimate termination versus pretext is I can go through that when we do the employment discrimination. So counts 3 and 4 have to stay, and they have to go to the jury. In terms of counts 1 and 2, Judge, we brief this endlessly. As you know, it's a McDonnell-Douglas test. We meet the factors. He's a member of protected class. There's an adverse employment action. He's qualified for the position, and he's discharged under circumstances which support an inference of discrimination. Now, they say that it has to be a similarly situated person on prong 4, but it's not. It's whether the person is discharged under circumstances which give an inference of discrimination, which is get your stuff and get out, because every time I'm down here, it's you complaining about racism. And it's the 2 white guys who are involved in the drug deal, one of them who overdoses, who don't get fired. And the black guy who there's no support for him producing these drugs for free to Khalib and Joshua, but they finger him, and he's the one that gets fired. So that should go to a jury. Hostile work environment. Obviously, Judge, the first portion of a hostile environment pursuant to ELCRA is a protected class, subject to unwelcome harassment that's severe and pervasive. There's case law we've cited, Judge. The use of the N-word in the workplace repeatedly is severe and pervasive as a matter of law. It's based on race, it affected a term or condition of employment, and that the employer knew about it, respondeat superior. So, Judge, we thoroughly fit into all of the causes of action, and all of the causes of action should survive. I have I could go on and on, Judge, but when you go down to it, even the defendant admits in their briefing that there are multiple different versions of facts that would keep the court from deciding this matter based upon summary disposition. I mean, they admit it. Every time they say, well, defendant says X, Y, and Z, but plaintiff says A, B, and C. In terms of telling Nick Young, they admit in their brief on page 10 that the plaintiff said that he told Nick Young denies it. And that's what this case is about. The racially hostile comments on the job site, for example, they say it's isolated, joking, or insignificant. We say it's repeated use of the N-word. It's racially charged political comments. It's humiliating conduct. And summary disposition is precluded because severity, frequency, and credibility are jury questions under Michigan law. The reporting of the racist conduct. They say he didn't properly report. He testified in repeatedly reporting. Conflicting testimony creates credibility dispute, which is inappropriate for C-10. Employee knowledge and response. They say they acted promptly and adequately. Plaintiff testifies complaints were dismissed as jokes, and the racism continued. Adequacy of remedial action is fact-intensive for the jury, Judge, which precludes summary disposition. the display of the Confederate and Trump flag. They say it was insignificant or promptly removed. We say that his complaints were dismissed as jokes and the racism continued. And again, that's adequacy of a remedial action is fact intensive for the jury. And the context and impact of a symbol, Judge, like a Confederate flag with a political message, is definitely an issue. And they say, for example, the black wooden penis, they say they dispute the racial meaning or knowledge of it. But plaintiff testifies it was intentionally placed above his work area, not somebody else's. And as a result of that, the motivation and the effect of that big black wooden penis display are questions of fact for the jury. This drug dealing allegation, 2 people involved in the drug dealing say that he supplied the drugs leading to the overdose. He denies
Mr.
it.
Rizzo, I can kind of, you're kind of repeating the same argument
Sorry,
over
Judge.
and over again. So I've heard that.
And you're right, Judge. I'm just going through, I guess I was winding up, and the court is very sharp. And you've heard what I have to say, Judge. I'm just highlighting that all of these arguments are classic questions of fact, which are going to make the most amazing jury trial, Judge. I hope that you are at the edge of your seat. The cross-examination is going to be amazing in this case. We're going to seat 8 very unbiased, very wonderful Wayne County jurors, and they are going to decide all these factual disputes for us, and it's going to be an incredible week or 2, Judge, that we get to spend on this case. That's
All right.
my
All right, thank you. Unfortunately, we're running out of time. It's almost 11 o'clock and I've got some other parties waiting for me. If you can check your calendars, as we spoke about earlier, it seems to me that you are planning to appear for a Friday motion. If you can check your calendars and let me know if you're available to appear not at 9:30, but at 12:30. And at that time, I can finish up Mr. Bean with any reply that you have, as well as take care of the motion, I think for extension of discovery. If you
Judge,
can
we
check
can do that at 12:30.
12:30,
Yes, Judge.
okay,
Let
Mr.
me,
Bean?
Yeah, I do have an all-day facilitation scheduled on Friday. I was going to have my son cover the motion for the discovery issue, but I can take some time at 12:30 to give you our response.
Are you sure?
Yep.
Okay, all right. So what I'm going to do is this matter is going to be adjourned until Friday, January the 23rd at 12:30 via Zoom. Your motion that is currently on the court's docket is going to be adjourned until that 12:30 time. So I'll see everyone back. If you could be prompt, I can finish up with this motion and then hear your other motion.
Very good.
Okay.
And your excuse me, Your Honor. Do I need to renotice or will this be?
You should renotice both of your motions for that date and time.
Okay. Sounds
All right,
good.
I'll see you
12:30
Friday, 12:30 via Zoom.
Thank you
Thank you,
very much.
Judge.
Thank
Okay,
you.
all right.
Thanks.
Bye.
Bye.